From the High 10. It's Everyday Shenanigans. I'm going to try to stream this press conference if I can. KGET.com is the source, and also Facebook if you need verification. The lawyers representing the adoptive parents charged with murder and the deaths of Orrin and Orson West are holding a news conference this afternoon. The conference will be held at 12:30 p.m. at 1318 K Street. The law office of Torres Stallings. Alexia Torres Stallings represents Jacqueline West and Timothy Hennessy's defense counsel for Trezell West. Prosecutors have said the boys, Orrin 4, Orson 3, were killed 3 months before they were reported missing. Their bodies have not been found. Trezell West, 35, told authorities the boys were playing outside while he gathered firewood December 21st, 2020. He said he briefly went inside, and when he came back out, the boys had vanished. Information received a week later led to the involvement of the Bakersfield Police Department, which eventually took over the investigation from California City. Dozens of searches were conducted, as well as digging at the sites in Bakersfield and California City. The couple was indicted March 1st. That's KGET News. Thank you all so much for joining me. I'm just waiting. I was calling, trying to make sure I'm directed in the right place. So I will see. Hopefully everything will come up. If not, I'll go into the Facebook and see what comes up. Thank you all so much for joining me. Okay. Oh, Lordy. What a mess. I don't know, my phone's been acting really strange. It won't. Keeps jumping off the screens for some weird reason. Lord have mercy. I don't know what's going on. It's in California, sweetheart. I just gave you the information. Jesus. Welcome everybody to the chat. Thank you for joining me. Hello, Susie. Hello, everybody. Dolly, CR, Small Fries. Thank you all so much for joining me. This is the press conference pertaining to the two defendants. I'm just waiting for everyone to reach the podium to speak. Thank you for joining me. This is Everyday Shenanigans. If you'd like to donate to the channel, $ began 129 Cash App. I'll super chat to welcome during the live. Thank you for your support. I appreciate it. Hello, Michelle. How are you? Hi, AJ. Hi, Susie. Thank you, sweetheart. Thank you very much. You're welcome. Thank you. I appreciate that, AJ. Hi, Candy. And please follow my other content pertaining to this subject matter. I made 2 lives yesterday pertaining to the case, Wanda West, and evidentiary material, court TV, and the original interview with Brian Wang and Chief Walker. Thank you for joining me. I don't do emails, sweetheart.
I'll get started. Good afternoon, everyone. Thank you for joining us here today. My name is Tim Hennessy. I'm lead counsel for Mr. Trezell West. Associated counsel with me will be Joshua Fleischman. He's not present at this moment. Here with me also is Alexia Torres-Stallings. She represents Ms. Jacqueline West. And associated counsel for Ms. Jacqueline West will be Ms. Fatima Rodriguez, here present to my left. This will be the only time defense counsel will be addressing the media, making statements about the case until after the trial. We won't be answering any questions here today. We won't be discussing any facts in the case. Our clients, we've spoken to them about this. They're behind this. They understand our need to getting our side out. Last week, our clients, Mr. and Mrs. West, were arraigned on an indictment of 5 counts, including second-degree murder, and that came as a result of a grand jury convene. There's been great confusion we've seen about the difference here between a grand jury and a trial jury, and the two of those things cannot be more different. First, the standard of proof is lower for a grand jury. They need to only determine probable cause, which is one of the lowest legal standards our system holds. They also do not require a unanimous vote by the jurors. The prosecution also has broad discretion in determining how to proceed and doing so by way of indictment. The grand jury process lacks a crucial and important role of our criminal justice system, and that is the accused and their counsel being present during. There is no opportunity to cross-examine any witnesses, and it is basically ran by the district attorney. This is to the detriment of the accused, as evidence of a speculative nature has a way of integrating itself into this most secretive of all legal proceedings. On the other hand, a trial by jury, they must unanimously agree on the issue of guilt or not guilty. And there you have the highest standard of proof, which is beyond a reasonable doubt, and it is a proceeding done in open court. The state's comment and reliance on this "we have proved to a grand jury" is mere rhetoric. It's used as an insurance to bolster a lopsided indictment. Comments such as this have no place in an actual court of law, where it is 12 individuals who unanimously decide the outcome of this case based on this highest level of burden of proof, which is beyond a reasonable doubt. Statements that have been used by the Kern County District Attorney in her press conference tend to invoke a tidal wave of emotion towards finding guilt, whether substantiated or not, and this will taint a local jury pool and can deny our clients a chance at a fair trial. It's odd that the office held their press conference, made a series of comments which both mis- and disinformed the public, then the following day came and requested a gag order to stop the defense from having an ability to make similar comments. This action is disingenuous, but may also cause change for a change of venue in the future. This is an election year, and this case is serving as a compass to guide the DA to her path of re-election. However, it is now when the misleads and theater end and the constitutional protections begin. The safeguards of the accused and the fight to preserve those for Trezell and Jacqueline West begin now. And I thank you.
Buenas tardes a todos. Gracias por acompañarnos a nuestra conferencia de prensa conjunta. Primeramente, me gustaría comenzar presentando a los abogados. Timothy Hennessy, el abogado principal para el señor West. Joshua Fleshman, abogado asociado con señor West. Y yo, Alexia Torres Stallings, abogada principal de la señora Jacqueline Martínez West. Fátima Rodríguez, abogada asociado de la señora West. Esta será la única vez que los abogados defensores se dirigirán a los medios de comunicación hasta después del final del juicio. No responderemos a ninguna pregunta hoy después de la conferencia. Tenga en cuenta que hemos hablado con nuestros clientes que están al tanto de la conferencia de hoy y tampoco discutiremos ninguno de los hechos relacionados con el caso. Comentarios como estos no tienen... Perdóname. La semana pasada, el señor y señora West fueron procesados por una acusación de 5 cargos, incluyendo asesinato en segundo grado como resultado de una reunión del gran jurado. Existe una gran confusión entre los dos jurados de juicio y los gran jurados, y los dos no podrían ser más diferentes. Primero, el estándar de prueba es más bajo para un gran jurado, necesitando solo determinar la causa probable. Uno de los estándares más bajos de prueba. Tampoco requieren unanimidad. La Fiscalía tiene amplia discrecionalidad para determinar proceder a través de la acusación. Este proceso carece de un papel crucial y importante del sistema de justicia. El acusado y sus abogados no están presentados durante el procedimiento y los abogados defensores no tuvieran la oportunidad de entregar a los testigos de la Fiscalía. En detrimento de los acusados, la prueba de naturaleza especulativa tiene una forma de congregarse con el más secreto de todos los procedimientos legales. Por otro lado, un juicio por jurado debe acordar unánimemente la cuestión de culpable o no culpable por el más alto nivel de prueba más allá de una duda razonable y hacerlo en juicio abierto al público. El comentario del Estado demostraremos el gran jurado es pura retórica, utilizado como garantía por reforzar su acusación desigual. Comentarios como estos no tienen cabida en el verdadero tribunal de justicia, donde 12 personas que le deben decir por unanimidad el resultado de este caso sobre la base del cargo mayor de la prueba más allá de una duda razonable. Declaraciones como la utilizada por la fiscal de distrito el condado de Kern en su conferencia de prensa tienden a evocar un halo de emoción hacia la culpable y sea fundamentado o no, que marcha el grupo de jurados locales y niega a nuestros clientes un juicio justo. Eso extraño que la oficina celebrar una conferencia de prensa, hiciera una serie de comentarios que desinformen y desinformen al público. Y luego, el día siguiente, envía a su abogado a la corte en busca de un orden de mortalidad. Esta acción no solo es insincero, sino que también puede crear una causa para un cambio de sitio en el futuro. Este es un año electoral y este caso sirve como la estrella norte que guía la fiscal hacia su camino de reelección. Sin embargo, aquí es donde terminan las trampas y el teatro y comienzan las protecciones y las salvaguardas constitucionales de señor West y señora West, los acusados. Muchas gracias. Thank you, everyone, for being here today.
Thank you.
I know you guys can't talk about facts of the case, but can we ask you questions about what it is that you said, just for further clarification?
About grand juries?
Yeah, exactly. So, just for like the common layperson, can you explain the difference between finding having probable cause in order to pass an indictment and the beyond a reasonable doubt? Just could you explain that a little bit further?
Generally speaking, yeah. So generally speaking, probable cause is the standard kind of being used day to day by law enforcement on whether or not to make an arrest. Right? That is is there a probability something here happened? Okay. Beyond a reasonable doubt is like that probably happened. I mean that I don't have my calculator in front of me, but it's the idea that that it is more probable than not that the guilt of this offense has been proven, right? The question is not should or not this person be arrested, and that's where we're at now. It was there enough for these charges to be brought? But the highest standard beyond a reasonable doubt, that's far off. That's so far from where we're at now. But because we hear jury, we hear grand jury, trial jury, there's this general sense to think, well, they must have proven this. This must have been proven beyond reasonable doubt, and that is not what happened. That is not what a grand jury is. A grand jury is a way to bring charges, much like how we have preliminary hearings all day, every day in the downtown courthouse. That's the same thing to get you in the same place. That they are two wildly different things, a grand jury and a trial jury.
Well, you have a preliminary.
I didn't know if you wanted me to. Did you want me to answer that in Spanish as well? I don't know. Okay. So, la causa probable es el más abajo forma de los estándares. So, por ejemplo, es cuando la policía hay un arrestado una persona, es el más abajo, lo más abajo. Y para las estándares de duda de razonable es más alta. So, por ejemplo, no es probablemente, no es posiblemente, pero es más alta de esos. Okay? Más alta de probablemente, más alta de posiblemente.
In terms of the timeline, when you guys will come forward, or is it still up in the air, depending on the information you guys
have? That's difficult considering the stage we're at right now. As far as what we know and need to prepare for, I do know that our position as well as our clients is to be vindicated as soon as possible.
Where do you guys stand on the gag order tomorrow, and why?
So I can answer that in English and then I'll go back. So we are going to be joining in the request for the gag order for a number of reasons. We do not want more misinformation to be spread before the jury trial. there has been very, very few number of cases that have had the opportunity to have a change of venue granted. I believe that there was one, not recently, but I believe that it came back on the Robert Mistrial trial, I believe was one of them. And so in order to ensure that our jury pool here isn't tainted, we are going to be joining on that gag order as well. ¿Quiere que yo decir eso en español también? Okay. So, nosotros queremos el orden también porque no hay muchos casos aquí en Kern County donde hay un papel de orden para cambiar el sitio. So, yo nomás piensa un jurado de Robert Mistrial, excuse me. Entonces, nosotros queremos juntar en pide la corte porque no quiere que personas aquí no tomen mucha información que no es correcto antes del jurado.
And there will be no prelim. No, there won't be a prelim because that is what the grand jury accomplished. So rather than proceed to prelim, it proceeded by way of grand jury, which is fine. It's an option, but it is to think that it is somehow superior or has proven more or means more. That's inaccurate.
When you guys say change of venue, could you just be a little bit more clear? What do you mean by that?
So if we go back to the trial that I cited earlier, that the incident took place here in Kern County, but the attorneys were able to prove in court that a significant portion of the people in Kern County were aware of the case and essentially argued that the jury pool would have already made up their mind had they decided to stay here. Again, these are not granted often, but it is something that we may be able to do considering the large amount of coverage that this case has garnered.
So basically, it would just be arguing it in a different district type of thing.
Right. Same trial, just in a different county. También para el español. So, en el orden para cambiar el sitio, no hay muchos casos aquí que eso es la realidad. Entonces, nosotros estamos diciendo que es posible para cambiar el jurado porque, por ejemplo, hay muchas personas aquí en Kern County que either sabíamos o tenemos una opinión de este caso. Por ejemplo, es más mejor para pedir a la corte para cambiar el county, pero es el mismo jurado.
And to clarify, are you guys saying the DA went the grand jury route for political reasons?
So, in viewing the press conference, I believe that she had indicated that they went the press conference route for some reasons that may have dealt with scheduling purposes. Although that can happen, there is also something that that counsel can agree to in order to allow the prelim to be continuous. She did state that there were a lot of high-profile cases in which they have chosen to go by way of indictment. Between Mr. Hennessy and our law firm, we were thinking of a couple of our high-profile cases, and those ones have not gone by way of indictment.
What challenges does this sort of present to you guys? You mentioned you guys have had these kinds of high-profile cases, but what sort of barriers are you guys now presented with? Obviously, there's the change in venue. Any other challenges that you guys are sort of facing or working through right now?
I would say in comparison to other cases, and I think one of the reasons why I wanted to speak today on behalf of Mr. West is the public's response to all of this has made it seem like it's a done deal. Like, why would you take this case? Why would you represent this person? He was found by this jury already. And to us, that's detrimental to the defense. That's like the fundamental purpose of this is innocent till proven guilty. And people are telling me, hey, it's a done deal. We saw it on the news. We heard it. A jury found him guilty. They proved it to a jury already. And to us, that's the most detrimental thing. Because this has to be a jury of people ready to sit, listen, do their job, hear the evidence, make a decision. And if the whole community already thinks that's a done deal, no one's going to show up and take this seriously, then we've lost already. And that is the point today, is to make it clear what it is that was done and what still has to be done before you want to convict our clients.
Y también cuando leen los comentarios de, por ejemplo, YouTube o de la media, también hay muchos comentarios que personas están diciendo que ellos están culpables, porque necesitan un jurado, porque un gran jurado ya dice que ellos son culpables. Entonces, esta es la razón que nosotros piensan que esta conferencia es más importante para correctar las palabras, los estamentos de la fiscal.
If you did the normal way, the normal trial, would you still take the case?
I'm so sorry, I didn't understand the
If they
question.
did it the normal way, like they did a regular trial, like normal, would you guys still defend these people?
Yeah, right. There's still innocent to proven guilty. It doesn't matter if that's a grand jury.
New message is received
Oops,
from
sorry about that.
1-833-417-2266.
Oops, sorry about that.
The ground we're working with not for everyone to understand. In place that they've been held to answer at a preliminary hearing.
Sí, porque es muy raro para hacer este tipo de audiencias. Es raro para hacer este tipo de audiencias, y también, like my counsel was saying, que ellos son inocentes ahora.
Can you guys confirm this case is being worked by you guys pro bono?
It
Is that
is,
what's going on?
it is not. So we are appointed through the Indigent Defense Panel. That is a program that is run through the Kern County Bar Association, and so that is how we have been appointed to the case.
And you guys are requesting a change of venue.
I think
Yes,
that's something we have to discuss further and see where
that's what they're gonna do. Lord
The
have mercy.
concern is that is where we end up. We'd like to avoid that it should stay in Kern County. It's Kern County's people. So, but that being said, I think it's something that we are aware of and paying attention to.
In establishing sort of like the timeline that you guys are going to be working with your and speaking to your clients as well, were you guys able to establish when exactly the West moved to California City?
I think that that's a little bit beyond the realm that we would like to discuss here today. We definitely do not mind talking procedure, but that's a little bit over what we wanted to discuss. Thank you.
You guys also said that there was some stuff that Ms. Zimmer said in the press conference that was like a little emotional, tugging at those strings. Could you talk specifically what were the stuff that she said that really struck you as bad?
She's not gonna speak on that.
It's not to say that this is not going to be an emotional case. However, we did believe that there was some phrasing that was used that to a lay person implicates one thing, but to an attorney or to many attorneys implicates another. When we hear stuff like, we proved to the grand jury, they were convinced, they believed, that isn't the standard in which they make their finding. And so to us, it was to more clarify that isn't the standard. That isn't to say that the grand jury aren't humans and that they obviously can't make up their own mind. It's just that that's not the same standard in which we know the standard to be.
And then one last question, just more of like if a person isn't a lawyer, a gag order. when is that implemented? What's sort of the standard that has to be met there for a judge to be like, yes, we're going to go forward with this?
I would say the request of a gag order is relatively routine in a high-profile case. I don't think there's anything out of the ordinary in requesting it. I think the only thing that didn't sit necessarily right with us was a press conference comes out and then they want to place a gag order. And I think to us it was like, well, we should also have our opportunity to address exactly what we've done here, how we see it differently. But other than that, not talking about the case, because the reason why then I think Alexia talked about this is kind of the essence here is we want jurors who are going to sit and hear the evidence, how it's supposed to be presented. Let this play out. I mean, this is one of the fundamental things our society has is trial by jury, and it needs to stay pure and be what it should be. And that be the 12 unbiased jurors listening to the evidence, making a decision. The minute that starts to seep into the jury pool and things change, that's our concern. We just want to get it now. So that's why tomorrow we would agree with the gag order.
There is currently, also a lawsuit that the county has placed on the West for. Are you guys sort of going to tackle that lawsuit as well? Are you going to represent them on that litigation as well, or is that going to complicate this for you guys a little bit?
So the answer to that right now would be no. It was my understanding that the lawsuit, the civil lawsuit, is filed by the biological father.
There's another one. So the county, the West, are facing like a child support lawsuit, I believe, for the other children.
Okay.
So there's the biological one, but then there's also the one from the county.
And you're not referring to a dependency issue?
It is the dependency one.
Okay. Then in that case, we do not represent them in that particular matter. They actually have other attorneys who have also been court appointed through the Indigent Defense Program who represent them in that matter. That is not to say that we aren't working together. It's just that we aren't representing them on that matter.
All right, with that, we're good.
Okay, thank you so much.
One last question.
Should tomorrow's motion for the gag order, should it be denied? Would that change your guys' stance, or do you think it would change your client's stance on further commenting on the details of this case?
Like you mean,
Like,
sorry,
in the beginning, you said that this would be, at this time, the only time you plan on addressing media and questions regarding the case. Tomorrow, should the gag order be denied and details come out before the trial or throughout the trial, would you guys consider readdressing media at that point?
So I think that at this point, if the prosecution and the defense are going to be joining in that motion, I don't necessarily see it being denied. The reality is that whether or not it is or is not denied, it would still be in our best interest to at least just wait until the trial. We don't want to use the potential motion for change of venue as a sword and a shield. We want to be able to articulate that motion if necessary and have it granted again if necessary, not by our own doing. So I think that regardless if it were or were not to be granted, we would still be abiding by the silence until the end of trial.
This agency you're talking about, did they come to you or did you go to them to take on this case?
The agency.
The indigent defense panel, it assigned us. We were available for appointment.
It did, but I will note that we are asked if we would like to take on a case, specifically Mr. Hennessy and I, and we did choose to take this on.
Sorry, just to go back again to the change of venue question, you guys did say you guys have to discuss it a little bit further as well. But what would it depend on to motivate you guys to ask for a change of venue?
There are specific factors that we have to look into, that we actually have to do research on before we could bring that motion to court. As an officer of the court, we are bound from bringing frivolous motions, and so we want to ensure that there is at least some basis for that. I will point out that as you all have been covering this case, I too have been reading everything that you folks have been producing. But specifically, I would direct you to that Robert Mistrial case. I did read an article several years ago that indicated that I guess at the time of the hearing that the court was able to establish that 72 to 79% of the county either were aware of the case, had an opinion about that case, etc. Again, they are these are motions that are not granted often, and so a lot of times attorneys have to go back to the cases before us to determine how something can be brought about.
I would think the sentiment from both of us is, as pleasant as this has been, we'd rather not be doing this. We'd rather not be thinking about a change of venue. We'd rather just get ready for a case going before a jury and trying. I think that would be our preference. I think in this one instance, because of the unique circumstances that got us here, we wanted to make this statement to point some things out before kind of shutting it down and doing it in trial like it should be done.
Anything else?
Thank you.
Okay, thank you.
Hold on first before we start the process.
Okay.
Then we're gonna start wrapping all this up.
Well, thank you guys, and y'all tricked us into answering questions.
They didn't trick you. You didn't have to answer. Crazy. All right, everybody. That's the news. Oh, mercy. Where do I start? Hello.
We begin our team coverage tonight of the West Boys.
Okay, hold on 1 second. Sorry about that. Basically, it's an issue of wording. Wordings used by the state, the district attorney, Ms. Zimmer, last week, basically saying that they have enough evidence to move forward, as if they've already got, these people have already made a decision, the grand jury, which we already know, common sense. The grand jury just hears the information and say yay or nay, and then you proceed to trial if they say yay, which that has happened. The grand jury has said yay, so now all parties meet up to press forward to a jury trial. The defense is not happy with the wording. They feel like this is possibly politically motivated, the wording and her acting as if everything's ironclad. But in the end, it is the state's job to prove beyond a reasonable doubt that these two exacted the crimes that they are being accused of. So, change of venue, they're saying basically they want to stay in Kern County because it is the Kern County people in the community that know of the information, the case, the people, But in the end, when you start mentioning it, people are going to question that. Why do you want to go somewhere else? You're saying, no, you don't want to go, but you mention it for a reason because you feel like there's biasness already in what the DA has stated in her info that they have ironclad proof. Well, that is what she said. I mean, you can either believe it or don't believe it. It's going to be up to 12 members of a jury to decide if they believe the information that's being brought forth. Is the evidence factual and self-evident? It's just the way it goes. It will be up to those 12 people. Now, we've seen in a case, very famous case of Casey Anthony, there was a lot of evidence that was circumstantial and I thought was ironclad enough, but 12 members said no. No, we're not going to vote to send this person to prison. And I think this is when you start to get a little worried because you want to be positive and optimistic that they will find the parties guilty. But we already have now these people whining that they feel like there was too much heavy usage for the prosecution, that this case is already sealed and deal. My thing is, even if you take it to another jurisdiction in the state of California, there's still a possibility that one person out of the 50 you interview has heard of the case, has already formed an opinion. Nobody's going to tell you directly, yeah, I think they're guilty, or no, I think they're innocent. People tend to keep that to themselves. That's why we've got this mess right now with Scott Peterson and a woman who was a juror and had been involved in domestic violence. She didn't mention it on the questionnaire. So now that's an issue, that she was not honest and forthright. But a lot of people are not going to tell you the truth that, yeah, I was an abuser, I did abuse somebody, or I was molested or hurt, or whatever the situation is in relevance to the trial that you're sitting on. People just don't tell the whole truth. They just don't. That's the chance you're going to take. What you have to do is pray that you will have enough information to combat what the state is accusing your clients of doing. As I said, this woman she's got her foot down to the pedal saying, I got what I need. And if she's got what I think she's got, it's really not going to matter to me. Let me say to me, where you take this trial. You can take it to New York. You can take it to Chicago. But if she's got video surveillance, like 3 months worth of them coming and going without 6 kids, you got to try to explain where the hell the other 2 have been for 3 months, defense attorneys. If they have evidence to show by video the children beating the children to death, to the final end, how are you going to explain that? Like I said, in my opinion, it doesn't mean the 12 members may see it in a different light if they're actually watching it. I'm speaking of myself personally. You've got video surveillance of them coming and going without the 6. Video of the crime. Anything from doctors' appointments, eyewitnesses to say they saw only the 4 for this amount of duration. That is what you're going to have a problem with. But as I said, anything can happen during a jury trial. People can still hear the information and still say, I don't believe it. They're lying. Something's off. Because that's the whole thing about information. It's about perception. What I see, you don't see. What I hear, you don't hear. So this lady could come up with everything she needs in this trial to show these people exacted this crime and use their children as weapons against 2 little babies. But that doesn't mean it won't be 1 or 2 that sits in the trial and says, nah, I don't see it that way. I don't look at it that way. And that's where your problem is going to be. This should be a very interesting trial because I am looking forward to seeing what is out there. I'm looking forward to see if they change the venue to another city or town in the state of California. But like I said, there's no guarantee that you'll get a not guilty verdict because you move the venue somewhere else. This is very, very interesting jump off. And we haven't even started the first day yet. We already got the defense perturbed by the usage of words and grammar by the state. It's going to be a crazy case. Woo, mercy. Hello, everybody. Thank you for joining me. So that is the said information. I read your article pertaining to Jacqueline and Trezell that they were going to be holding a press conference and just a bio of what happened in the past year pertaining to the children going missing. They're now being charged with second-degree murder. Their lawyers spoke in this commentary. They're being represented by defenders. I guess they're state defenders. And then it was a mention about some other people that are representing them in some other issues. They've got, naturally, they're being sued by the bio father. I didn't hear a mention of a bio mother in that said commentary. I don't know if she's on the paperwork to sue the state. We will see what happens in the civil suit. But we already know that when it comes to suing the state, that's just a hard bunch of people to win against. And the government in general. Because the government is going to always feel like whatever decision they made, they were right. You know, it's not like suing a regular Joe. You're suing the state. And most officials stand by states' decisions. And I think we've seen that in several cases where people have tried to sue the state for certain issues. And the state, it's like they stick together. I don't know where the bio mother has been. You have to ask her, Miss Masters. I don't know. I haven't a clue. But this is some interesting information. Very interesting information. I don't see the civil suit going anywhere. Because as I had said to you all previously in my commentary, that there are photographs of the said bio parents, you know, in pictures with their children visiting. So that means it's not like you never knew that your child was taken or in the state's care. You did have contact with the agency at some point alongside your children, because there are photographs that were posted to social media with both parents in the photographs with the kids. So it's not like you didn't know your children were in the state care, and you're going to have to prove beyond a shadow of a doubt that somebody hoodwinked you, bamboozled you out of keeping your kids and severing your rights. You're going to have some proof. And that's the said word on that. Ooh, Lord, not a dish rag. Girl, you killing me. Play nice, Kinsley. Play nice now. Be nice, young lady. But that's the sad information coming out of California. The defense felt like they didn't get a chance to respond last week to the grand jury's findings and the information brought by the district attorney. And she's basically said she's got an ironclad case. She's got what she's got, and she's confident about what she has. So they're feeling like, well, maybe this is wording coming out of her mouth because of it's, vote time. So as I said, you're entitled to think what you want in your perception of what the lady said during the press conference last week, Ms. Zimmer. If you believe that she has she's adamant about what evidence she has against Jacqueline and Trezell West. One thing I found interesting is when he said that his clients want to get a speedy trial, they're ready to start. Yeah, I know they're ready to start because they don't want to be in jail. So if they're ready to get started, I'm ready to get started too, because I want an ending to this. I want an ending to talking about these kids, because it's been long enough. 1 year is enough. And I thank God it did not go any longer. So Jacqueline and Trezell say they're ready to go. They want to get the trial started. They want to get it crunked. We want to get it crunked too. We're ready too. So defense attorneys, go do your homework. Go do your homework. Pull your big boy panties up, big girl panties up, draws up, whatever you got to do. Let's get this party started. Since your clients say they're ready. They want to get out the truth about what happened. But as I said, the truth is about your perception. Because as I said, if there is a videos of the crime, I'm going to speak, as I said, from my own perception. I don't know how you're going to refute it, especially if it shows the front to the end, which means the start of the altercation to the moments the children had no breath left in them. You want to sit there and have that played out in a courtroom and think somebody on that jury is not going to be empathetic to watching small children die on a camera. But like I said, all it takes is the one to say, I didn't see what you all saw. Have mercy. Oh, mercy. Mercy, mercy. I don't know about them making a statement. I just know the lawyer spoke. I don't think they're going to speak. It's up to the attorneys, to give them the advice to speak or not to speak. And the way this sounds, it sounds like she said they're going to go all the way to the end, possibly without them speaking. Because usually they don't advise defendants to speak on their behalf in jury trials. They just don't. Well, one might flip. It just depends on what happens. See, what determines people flipping is what comes out in court. You see, as the information starts to come out, as people start testifying, as they start bringing evidence, that's when people start realizing, maybe I should have said something earlier. Oh, I didn't know they had that and this and that. But my thing is, what you did to the kids. You know what kind of life you have with the kids. You know how you raised the kids. So really, it shouldn't be any surprise what they bring into court as evidence and eyewitnesses either. You lived around people. You had neighbors. You've got relatives. You've got associates. There is that chance that they've talked to these people and they're going to testify. It is what it is. Yes. Hollerville too. Well, that's basically it, you guys. Feel free to go to kget.com or the Facebook for KGET News to rewatch the said information. The defense has spoken on behalf of their defendants, and the defendants are ready to press forward with this trial and get the information out there, and as he said, to get their side. Now, many people probably are going to say, what side do you have if you aided kids to kill kids? I agree, you don't have a side. So I don't know what you're trying to go to trial and talk about, actually. But when you're a narcissist, a sociopath, psychopath, that is your mentality. It doesn't matter what they got. I don't care. I'm going to prove otherwise. I'm going to say otherwise. Hear me out. I've got a side. I've got a version. So that's why I am looking forward to seeing what the state has against the two. Because what will be just outright crazy is if it's what I think. The children told it. They have it on video. They've got surveillance video of them going and coming around Bakersfield and Cal City without the 6. How are you going to explain that? How are your lawyers going to explain where were the other 2 children? So then what is your response going to be? Especially if they start going day for day, week for week. Oh, I only see you with 4. I only see you with 4. What are you going to say where the other 2 were? Because if you say, oh, they were over here, they were with Pookie, they were with Marquisha, well, then guess what? The state's going to say, well, I want to talk to Marquisha. I want to talk to Pookie to see where they keeping your other 2. And you know it's a lie. So how's that going to work? It's not. Thank you all so much for joining me. If you'd like to donate to the channel, $BeGanji129 Cash App. When I get more information pertaining to this trial that's going to start in May, hopefully on time, I will bring you the said commentary, any other updates pertaining to Jacqueline and Trezell West. I will bring you that said information. Please go into the queue to check out the latest uploads I have put in from yesterday. I have 2 lives from yesterday pertaining to Wanda West and the evidentiary material pertaining to this case. There were 2 back-to-back lives I did last night. So please check out that said commentary. You all have a safe and beautiful week. It's raining here in the Hot End. I will talk to you guys later. Join me possibly later or tomorrow with a crime vault storyline. This is Everyday Shenanigans. You all be safe.